Very warm good evening to all. Today we will be discussing a topic on criminal trespass. Now this is a topic where more than 20 sections are allotted in Indian Penal Code. Now this topic is very important because most of the crimes are committed in dwelling houses also. It's not always everything happens on the road. So being a crime, it is always done behind the closed door also many times. That's why this chapter is very important. Now we will go through some of the section to make you understand all of you. I'll be sharing some of the important sections from this. We'll go through the main index here from the Indian Penal Code, where you will have an idea. See, if you see, I've shared the screen. Can you all see? It is of the criminal trespass. Now here, section 441. I will elaborate, try to. Section 441. From there to till 462. Almost 22 sections, I believe. I've not counted, but more than 20 sections are there. Now this is, we won't be able to cover all these sections today, but I'll be trying to cover few of these sections to make you basic understanding of the criminal trespass. Now trespass is something in going in somebody's house or going in somebody's property, entering the property where we are not allowed to enter by law. Now we go to the section 441. Criminal trespass. Whoever enters into or upon property in the possession of another person with intent, see there should be the word bahut dhyan rakhna aap log, with intent to commit an offense or to intimidate, dhamkana, insult or annoy any person in possession of such property, or having lawfully entered into or upon such property unlawfully remains there with intent thereby to intimidate, insult or annoy any such person or with intent to commit an offense is said to commit criminal trespass. Now just look at this, the words used. See, whenever you will be asked, what are the ingredients of the criminal trespass? Now whoever enters into, I'm reading the definition again. Into or upon property in the possession of another person with intent to commit an offense और टू इंटिमिडेट, उनको धमकाना, इंसल्ट करना, अपमान करना, एनॉय करना, चिढ़ाना या किसी तरह से इरिटेट करना एनी पर्सन पोजीशन ऑफ सच प्रॉपर्टी, जिनकी प्रॉपर्टी उनके पोजीशन में हो, और हैविंग लॉफुली एंटर इनटू और अपॉन, या फिर लॉफुली एंट्री किया, अपने आप एंट्री लॉफुली मेरे घर पर आए बट अनलॉफुली रिमेन्स, मेरे मना करने के बावजूद आप वहां रह रहे हो, there with intent thereby to intimidate, insult or annoy any such person or with intent to commit an offense is said to commit a criminal trespass. Now next we go to the simplest thing, house trespass, 442. Whoever commits criminal trespass by entering into or remaining in any building, tent or vessel used as a human dwelling, जहाँ लोग रहते हैं, or any building used as a place for worship, किसी का धार्मिक स्थल है, or as a place for the custody of the property is said to commit house trespass. Explanation is also given there, but we won't go to explanation. Now next is lurking house trespass. Now lurking house trespass is, lurking का meaning itself गुप्त and secretly without anybody knowing it, without, जब आप without information जाते हो तभी lurking house trespass होगा. Whoever commits house trespass having taken precautions to conceal such house trespass from some person who has a right to exclude or eject a trespasser from the building, tent or vessel, which is the subject of the trespass, is said to commit lurking house trespass. Now here see, lurking house trespass मतलब आप बिना बताए किसी के घर में घुस गए, किसी बिल्डिंग में घुस गए, किसी शॉप में घुस गए. Now lurking house trespass by night. Now night is different, and see, lurking house trespass simply is different. 445, 44. Whoever commits lurking house trespass after sunset, रात होने के बाद, and before sunrise is said to commit lurking house trespass by night. Now there are different punishment to all this because रात में आप किसी के घर में चले जाते हो, so maybe there must be some intention. Next is house breaking. This is very important. जो काफी यूज भी होता था पहले, अभी इतना नहीं होता है, बट हाउस ब्रेकिंग का केस है. इफ यू गो टू क्रिमिनल मैटर्स और क्रिमिनल कोर्ट से हाउस ब्रेकिंग का केस है. अ पर्सन इज सेट टू कमिट हाउस ब्रेकिंग who commits house trespass if he effects his entrance into the house or any part of it any of the 6 ways hereinafter described. तो 6 रास्ते बताए उन्होंने. And if being in the house or any part of it for the purpose of committing an offense or having committed an offense therein, he quits the house or any part of it in any of such 6 ways. That is to say, now we will read this. First, if he enters or quits through a passage made by himself, कुछ वहां पर छेद किया, होल किया, or by any abater of the house trespass in order to committing of the house trespass. Secondly, if he enters or quits through any passage not intended by any person other than himself or an abater of the offense for human entrance or through any passage to which he has obtained access by scaling or climbing over any wall or building. Explanation very simple. Wall पे चढ़ के किया, building में छत से कूद कर किया, फांद कर किया. Thirdly, if he enters or quits through any passage which he or any abater of the house trespass has opened in order to commit, in order to the committing of the house trespass by any means or by which that passage was not intended by the occupier of the house to be opened. ऐसा रास्ता जो उन्होंने कभी खोला नहीं था किसी के लिए. If he enters or quits by opening any lock in order to the committing of the house trespass or in order to the quitting of the house after a house trespass, ये वापस पहले आ गए एंट्री और फिर बाद में कहीं छुपके से निकल गए. Fifthly, if he effects his entrance or departure by using criminal force, जबरदस्ती घुसना, or committing an assault or by threatening any person with assault, बोला कि आप नहीं दरवाजा खोलोगे तो मैं कुछ धमकी देना इस तरह की कि मैं आपको मार डालूंगा. Sixthly, if he enters or quits any passage, enter or quits दोनों दिए हैं देखिए, which he knows to have been fastened against such entrance or departure and to have been unfastened by himself or by an abater of the house trespass. This is again कि ऐसा entrance या ऐसा passage जो उन्होंने अपने लिए बनाया या उनके लिए नहीं है, तो जबरदस्ती से घुसना. This way. The explanation, any outhouse or building occupied with a house or between which and such house there is an immediate internal communication, it's part of the house within the meaning of this section. हो सकता है किसी के घर में आउट हाउस भी हो छोटा सा, which we found in north side houses where there are big houses. Now next we go to the 446. There is house breaking by night. Whoever commits house breaking after sunset and before sunrise said to commit house breaking by night. Next is very important section, punishment for criminal trespass. Whoever commits criminal trespass shall be punished with imprisonment of either description for a term which may extend to 3 months or with fine which may extend to 500 rupees or with both. Now this will go on and we can read many sections. There are more than 20 sections here. So always see that trespassing is a very wide subject. And whenever you are filing a private case, there is a possibility that when you go to the police may not register your FIR. In such kind of matters, if anybody has come to your house, you have to go through all these sections. And see, whenever you read section 441, there is a word insult, there is a word intimidate, there is a word annoy. These are very important. There is all this forcefully entry karna. Is a wording, आपका ingredient should be there. And these ingredients, if there is any complaint, you can always tell the court, add this section. See, sections can be added or deleted from as per the CRPC anytime. But then if you know it, then only you will be able to tell the officer who is in the police station or the presiding court officer that this section may be added. So house breaking, house trespass is one of the important part of the criminal practice, and almost a very big chapter in the IPC is devoted to the same. Now next we go to the Shivani. Can you unmute yourself? Shivani, you have to start reading from here.
Yes.
Amit ji is to the left.
Am I audible?
Yes, you are audible.
You have to okay. Exhibit Plaintiff 13 is the post-mortem certificate. Preserve the internal organs and sample blood for examination. After receipt of Exhibit Plaintiff 9 Viscera report, prosecution witness 14, doctor gave Exhibit Plaintiff 14 final opinion. The doctor opined that the deceased would appear to have died of cyanide poisoning. Prosecution witness 16, in continuation of his investigation, recovered the motorcycle produced by prosecution witness 11 under Exhibit Plaintiff 27. Prosecution witness 10, Inspector of Police, attached to the government fingerprint lab, Trichy, received the intimation from Inspector of Police. Prosecution witness 16. He went to the scene of occurrence along with prosecution witness 16 on 30th March 2009 at 8 a.m. He found the beer bottle, MOI and soft drink, 7-Up bottle, MO2. He examined the two bottles to find out whether there is any fingerprints available in the said bottles. He found two fingerprints only in the beer bottle, MO1, which are marked as R1 and R2. He has also taken photographs. He examined and compared the fingerprints taken from the beer bottle, MO1, along with the fingerprint of the deceased, and the said fingerprint found not tallied with the fingerprint of the deceased. He also received the fingerprint of A1, and on examination, prosecution witness 10 found that the fingerprint of A1 are tallied with the fingerprints found on MO1 beer bottle. He has sent the report Exhibit Plaintiff 17 to the investigating officer, prosecution witness 16. Prosecution witness 16, on receipt of post-mortem certificate, Exhibit Plaintiff number 13, final opinion, Exhibit Plaintiff 14, serologist report, Exhibit Plaintiff 15, comparison report, Exhibit Plaintiff 17, certificate of latest fingerprint examination, Exhibit Plaintiff 19, completed the investigation and led the charge sheet against the accused on 30th April 2009 for the offense under section 302 109 IPC. The prosecution, in order to bring home the charges labeled against the accused, examined prosecution witness 1 to 16, filed exhibit plaintiff 1 to plaintiff 29, and marked MOS 1 to 11. When the accused were questioned under section 313 CRPC in respect of incriminating materials appearing against them through the evidence adduced by the prosecution, the accused has denied each and every circumstances as contrary to the facts and stated that they have been falsely implicated in this case and they have not chosen to examine any defense witnesses on their side. Mr. V. Kathir Velu, learned counsel for the appellate contended that the prosecution has miserably failed to establish the case beyond reasonable doubt against the accused by adducing clear and cogent evidence, and put forward the following contention. Contention number A is the entire case rests on the circumstantial evidence, and the prosecution has not produced any clinching and incriminating circumstances against the appellant. The prosecution has chosen to place reliance on the alleged extrajudicial plaintiff 1. The last scene you said to have spoken, but prosecution next and fingerprints have the aspect opinions, but the keys found on such evidence as distribution is able to be to the village of project of the accused, and as have confidence on prosecution witness one, give the extra scene 3 witness 6 who are also A1 as well as to the deceased as their categorical admission in cross examination, and the prosecution also not use any identification for prosecution and as such the official witness and unreliable.
Shivani, we are unable to hear you properly. See the chat box also.
Categorically stated in evidence that this is anyone.
Shivani.
So from my side, it is
Hello. Read one para. We'll see. Read. Continue. No problem. Continue. But we are unable to hear you. So there are messages in chat box also. I thought a lot of people are unable to hear you. Maybe network issue. Shivani? Shivani, may I request you to stop because we are unable to hear you. Vandana, you can. We are unable to hear you.
Yes. Am I audible now?
Now audible. Start.
Am I audible now?
Hello. Start if you can.
Okay. Who prosecuted 6 and 7? It is that disease and A came in a motorbike. This bike was admitted.
Shivani, we are unable to hear you. Shivani, wait.
And prosecution witness 16 categorically in his.
Shivani, wait. Shivani, wait. Vandana, you can start reading. Start from this. Shivani, wait. Really sorry.
Ma'am, D point.
Yes, start from here.
The last seen theory said to have been spoken by prosecution witness 6 and 7, who are also total strangers to AI as well as the deceased as per their categorical admission in the cross-examination, and the prosecution also not chosen to conduct any identification parade, and accused one was identified for the first time before the court by prosecution witness 6 and 7, and as such the evidence of prosecution witness 6 and 7 is unbelievable and unreliable. Though prosecution witness 6 and 7 categorically stated in their evidence that the deceased and accused number 1 came in a motorbike, the said motorbike was not found in the scene as per the admitted version of prosecution witness 16, and prosecution witness 16 categorically admitted in his cross-examination that he has not recovered the motorbike material object 4 from the scene of occurrence, and the said motorbike material object 4 was recovered from some other place and from some other person. Per contra, the learned additional public prosecutor would contend that the prosecution has proved its case by adducing clear and cogent evidence. It is contended that the prosecution placed reliance on the extrajudicial confession EX P1, the last seen theory spoken by prosecution witness 6 and 7, and the fingerprint of accused number 1 found in material object 1 beer bottle tallied with the fingerprints of accused 1. It is contended that there is no serious infirmity or inconsistency in the evidence adduced by the prosecution in respect of the above said circumstantial evidence. The learned additional public prosecutor would further submit that prosecution witness 6 and 7 categorically stated in their evidence about the deceased and accused 1 coming to the scene of occurrence in a motorbike, and as such the deceased was seen along with accused 1 lastly by prosecution witness 6 and 7, and as such the said incriminating circumstance put forward by the prosecution is clinching against accused 1 in the case. It is contended that prosecution witness 1 being the village administrative officer, the appellant accused 1 thought it fit to confess before him, and as such the said extrajudicial confession cannot be rejected. It is also pointed out that the motorbike material object 4 recovered by the prosecution to substantive the version of prosecution witness 6 and witness 7 as the deceased came in the motorbike along with accused 1. The learned additional public prosecutor would submit that though there are certain minor discrepancies in the prosecution case, the same cannot affect the main case of the prosecution. We have given a careful and thoughtful consideration to the rival contentions put forward by either side and also thoroughly scrutinized the materials available on record and perused the impugned judgment of conviction. The fact remained that the entire prosecution rests on the circumstantial evidence. The prosecution has chosen to place reliance on the following circumstances, namely the extrajudicial confession EXP1 alleged to have been given by accused 1 to the village administrative officer prosecution witness 1, the last seen theory said to have been spoken by prosecution witness 6 and 7, and the fingerprints of accused 1 said to have been tallied with the fingerprints found in material object 1 beer bottle. Before proceeding to analyze and access the above said circumstances put forward by the prosecution. Ma'am, you saying something?
No, continue.
Okay. Let us now refer to the settled position of law laid down by the Honorable Apex Court in respect of the reliability of the circumstantial evidence and test to be adopted by the courts. The Honorable Apex Court has reiterated that the following tests have to be satisfied in a case rest upon circumstantial evidence in a latest decision in Krishnan versus State, represented by Inspector of Police, reported in 2008 for Supreme 25. The Honorable Apex Court has held as follows. This court in a series of decisions has consistently held that when a case rests upon circumstantial evidence, such evidence must satisfy the following test. The circumstances from which an inference of guilt is sought to be drawn must be cogently and firmly established. Those circumstances should be definite tendency, unerringly pointing towards guilt of the accused. The circumstances taken cumulatively should form a chain so complete that there is no escape from the conclusion that within all human probability, the crime was committed by the accused and none else. The circumstantial evidence in order to sustain conviction must be complete and incapable of explanation of any other hypothesis than that of the guilt of the accused, and such evidence should not only be consistent with the guilt of the accused, but should be inconsistent with his innocence. Gambhir versus State of Maharashtra. It is also equally well settled by the Honorable Apex Court in Gade Lakshmi Mangaraju alias Ramesh versus State of Andhra Pradesh, reported in AIR 2001 SC 2677, state that in a case based on circumstantial evidence, one circumstance by itself may not unerringly point to the guilt of the accused. It is the cumulative result of all circumstances which could matter. Hence, it is not proper for the court to cull out circumstance from the rest for the purpose of giving a different meaning to it.
Wait.
Now let us
Wait. See, what we read today, still there is a small part of the judgment which we will be continuing reading tomorrow. It is about the last in theory. Last in theory is not somewhere explained, but it is explained through some few judgments. If you, the meaning behind the last in theory, that there is a possibility that there are two person in the room, and one person dies. Another person has to give cogent evidence, cogent explanation that what has actually happened in that room. Unless he is able to give the reason that he doesn't know what has actually happened. If a person dies in a blood of pool and another person is found in room, he has to answer. There is a possibility two people are going together to the work and coming together back from the work. But one day they do not come together. Then the person with whom in the morning he went, he is supposed to tell what has happened. So that is the last in theory. So last in theory is very important in the criminal practice. So if your client, litigant is caught in a last in theory, and if you are unable to give a cogent, that is the word repeated again, if you are not able to give the cogent evidence or cogent explanation, the person was with me, but now why he's not with me? What is the reason where we got separated? What has happened? If I and Vandana go together in the morning to the court, in the evening I come alone, then I have to give explanation from me and Vandana where we separated. So this is very important. The last in theory, find out for a few more judgments on the last in theory. It is a circumstantial evidence, but more than circumstantial evidence, last in theory is very important, that your client should be able to give a good explanation, cogent explanation to the court, to the prosecution, to the police authorities, that this is the reason. I do not know what has actually happened after I left. So this is very important. Now we go to the another part, that is reading of the some important words which we can use in the legal vocabulary. I've drafted few words. Sought. The relief sought by the petitioner is fair and reasonable. See, whenever we go to the court, we ask that I'm seeking relief. See, seeking sought, these words are very important. Relief sought by the petitioner is fair and reasonable. What has been sought by the petitioner? जो petitioner चाहता है वो fair और reasonable चीज है. The sought word is very important if you can use it. Business establishment. We always write it's a company and so many things. The business establishment should pay their taxes on time to avoid any penalty. This is our flowery language. To any penalty in future and for the smooth functioning of its entirety. Gross delay. Now, gross delay is a very common word. Yesterday we read inordinate delay. There is a gross delay in approaching this court by the petitioner, hence no relief can be granted. Now, delay and laches. The delay and laches in filing the petition cannot be condoned as it is self-created. जो भी इसमें कमियां है या देरी हुई है तो डिले लेजेंस फाइलिंग कैन नॉट बी कंडोन बिकॉज काफी सेल्फ क्रिएटेड है, जानबूझकर किया गया है. कॉम्पिटेंट अथॉरिटी. नाउ माड़ा इज अ कॉम्पिटेंट अथॉरिटी, ऑलवेज रिमेंबर. जो गवर्नमेंट की कुछ अथॉरिटी जो सेल्फ ऑटोनोमस होती है उनको बोलते हैं कॉम्पिटेंट अथॉरिटी. driving license issued by the competent authorities valid throughout India. Subsequent, very common word, but how we use it. Once you are a repeat offender, then you will be punished rigorously for every subsequent offense. Acceded to. Acceded to is like sweekar karna. The court acceded to their demand for more time to file reply. The court accepted it. The court acceded to. Is innocuous prayer. Now, innocuous meaning of the innocuous is harmless. जो किसी को harm नहीं, innocent बोल सकते हैं. The prayer of the petitioner is innocuous, and it can be acceded in view of his undertaking. Mala fides. It is a opposite of bona fides भी बोल सकते हैं. The intention of the respondent was mala fide. गलत उनका ये था intention in not attending the court and protracting the trial. See, the word is protracting the trial. यानी ट्रायल को लेट करना. नेक्स्ट है बोनाफाइड्स. By depositing money for settlement, you can show your bona fides. When we say we want to settle, we say you deposit a part of the money in the court and show your bona fides. अब आपकी कि आप सच में सेटल करना चाहते हैं, ईमानदारी से बताइए, पुष्टि कीजिए. Cannot second guess. Very simple English, but see how it is used. There cannot be second guess about his complying with the orders when he failed so many times. उन्होंने पहले भी कोर्ट के आदेशों को नहीं माना है. Brush aside. Very simple English, but it is used beautifully in few of the judgments. The objections taken by the public prosecutor was brushed aside, and the accused application was allowed. Best practices. The best practices to read the best practice is to read the judgment as a whole and then only cite it before the court. अच्छी आदत यही होगी कि आप जजमेंट को पूरा पढ़े and फिर कोर्ट में बताएं. Judgment emphasize. Judgment emphasize. This is the common word you will be finding in mostly in the few of the judgments when you read on the websites. The majority of the judgments emphasize, जोर देते, that the father should take care of daughter's expenses till she is married. Breach. The other party has committed a breach of contract. Very simple word. In spite of contract तोड़ा या contract broken नहीं बोलते, breach of contract. In spite of clear cut averments there. Averments या उसमें जो clauses थे. So English is very simple language, but when it comes to law, you should be able to use the words which is off from the legal vocabulary. Now this legal vocabulary can be developed, one by reading judgments, another by making few of the sentences. Every day try to make 5 to 10. You can make a notebook of the same, and or in your email also, email box also you can do that, but try to learn 5 to 10 words each day. This will add, and subconsciously or unconsciously you will be using those words in your talking and when you are appearing before the court, and trust me, it actually impresses the court when you use the legal vocabulary. So this was all about today. We have 5 minutes. Anybody wants to speak? You people can unmute yourself if anybody wants to ask. Anybody wants to introduce themselves? Anybody from Gadchiroli, Amravati? I've written in the chat box. I mean those who are practicing from that area. Amravati, Gadchiroli, Sangli, Gondia. Gondia court I have been many times. I've run a trial. There is also one small village, Tiroda, which comes between the Nagpur and the Gondia. There I have run a domestic violence trial. The client was from Thane. Anybody wants to introduce? Take an opportunity. We are 60 plus people. Okay, I will make a use of the same. I'm coming with a drafting book because a lot of juniors has a difficulty in drafting. I learned to use my own way, and with the help of my seniors, I tried to imbibe from them. But then the secret to drafting is keep on reading, and keep on reading not only the judgments, also the other people's briefs or the what we call is case papers. So whenever you get any papers from even of the opposite lawyer, try to read it, because you never know who uses the good language, who must be using the legal vocabulary. So try to, nowadays on the internet you find so many judgments also, and you find so many stuff related to legal profession also. There may be writ petitions, so please you can use that. मनीष जी, आप कैमरा ऑन करके बोलिए तो अच्छा लगेगा. रोहित इज आस्किंग हाउ टू डेवलप अ डीपर अंडरस्टैंडिंग ऑफ द कॉन्स्टिट्यूशन. कॉन्स्टिट्यूशन के लिए आई वुड रिक्वेस्ट यू कि अभी एक बहुत राइट टू प्राइवेसी पे बहुत अच्छा जजमेंट आया है अबाउट 2 years ago, पुट्टा स्वामी का. तो आई वुड रिक्वेस्ट, मैं देखती हूँ ग्रुप में डालूंगी, आप वो पढ़िए. कॉन्स्टिट्यूशन में आप अच्छा कर पाओगे. आई एम वेरी हैप्पी रोहित हैज आस्क्ड दिस क्वेश्चन कि कॉन्स्टिट्यूशन का कैसे आपको है टू रीड कॉन्स्टिट्यूशन. डीडी बसु का जो बुक है वो आप रीड करना स्टार्ट कीजिए. इट इज वेरी सिंपल एंड फॉर अस इट इज फ्रॉम लीगल प्रोफेशन से जो भी है डीडी बसु पढ़ते हैं उनके लिए वो बाइबल है, मेरे लिए वो बाइबल है. तो ट्राई टू रीड दैट. ऑल्सो जो कॉन्स्टिट्यूशन पे जजमेंट्स आते हैं सुप्रीम कोर्ट से, मोस्टली ऑल द कॉन्स्टिट्यूशन जजमेंट्स आर फ्रॉम द सुप्रीम कोर्ट. इवन हाई कोर्ट डिलीवर्स इट, but Supreme Court के judgments, these are affecting the whole country. So try to read it. Book name is DD Basu. I'll write it. In fact, I have. मैं कोशिश करूंगी कल का इसमें आपको बुक का ये भी डाल दूं. DD Basu 2 volumes. सिंगल वॉल्यूम वाले भी ले सकते हो आप लोग अभी, लेकिन 2 volumes में काफी अपडेट रहेंगे और थोड़ा कमेंट्री रहेगा. And whenever you want to read any book, no, try to buy a commentary वाली book. तो आपको थोड़ा रीडिंग मिलेगा. But don't buy so many books in the beginning.